much, and thank you for tuning in to our show. And now we are going to move into our segment. It's called the Hello Roll. Today we have a very special guest, which is Mona Dandy. And now I would like to discuss about the English jury system in nurturing fans. Hence, let's move on to our first guest.
Thank you, Ben. It's been a while since someone invited me to a talk show because I've been dead for so long.
Well, alright today. Well, I'm going to talk about the topic of the jury system.
My favorite.
Miss Dandy, would you like to give us a little bit of introduction on the jury system?
The jury system is an incorporation of the British citizens into its ambits of a jurisdiction parallel to the principles of democracy, where the public is able to participate in the process of the country's jurisdiction. Moreover, this is the right to a trial by a jury of peers. It is enshrined in the English law in Article 39 of the Magna Carta.
If the audience didn't quite understand the rich history of the jury system, giving you a brief history. Jury system was imported to Britain after the Norman conquest. The early jurors in England were initially witnesses who provided information on local affairs. Subsequently, under Henry II, the jury began to deliberate on evidence produced in the dispute between two parties. Hence, we can see that the post it shapes our present times. Ms. Dandy, do you like to give any examples that shows the application of the jury?
Yes. Based on the case R versus Wang, in 2005, a jury's decision is always independent of the judge's.
According to the latest figures from the Ministry of Justice, there were about 35% of chance of people in England and Wales were being summoned for jury system over the course of their lifetime.
No, I know. Based on the research on BBC News on the 28th of April 2006, there are about 30 men and women who will be invited to court, and 15 will be selected to be part of the jury.
It is true. In fact, the chance of actually serving on the Scottish jury is around 30%. Ms. Dandy, could you like to tell us more about the functionality of the
One of the main functions of the jury is to weigh the evidence and decide which are the true facts of the case, and to decide what actually happened. Their responsibilities will be on the matter of the facts of the law provided by the judge. The jury can acquit the accused if there is insufficient evidence to convict them. Not only that, there is no corresponding power to instruct the juries to convict. The juries can only take into account and to be attentive to the evidences presented in the courts.
concept of the public composition, and it does reflect the opinions of the general communities. The juries would decide whether the defendant was guilty or innocent, but will not interfere within the ambits of responsibilities of the courts. In the criminal cases, if jury were to give a guilty verdict, the judge metes out the appropriate sentences. Therefore, juries only decide 1% of the criminal cases, and it's still being considered significant because 1% amounts to 30,000 criminal cases.
In civil cases, jury can decide how much money is awarded in damages. Usually, in the civil cases that are judged by the juries include malicious prosecution, false imprisonment, and fraud under the Senior Courts Act of 1981. However, nowadays, trial by jury is in the civil system and almost
Are
obsolete.
the implications, and when there's a contempt in court by the juries.
If jury breaches any of the rules, commits to any misconduct in a trial, it amounts to a criminal offense of the contempt of court under the Contempt of Court Act 1981. We can see this issue surfaced in the case of R versus F in 2009, where two jury members were seen talking to a law student who was watching the trial. This also results in the convictions being squashed.
Do you know what situations where the jury system is being applied into the courts?
Alright, in the present day, the jury system is used to the following courts. Firstly, Crown Court. For the matters concerning criminal indictment, for example, serious criminal offenses such as murder, manslaughter, and rape, there will be a jury consisting of 12 members. 50 members will be called upon to complete the jury service. Of these, 12 will be randomly selected to hear the case.
About the high courts. Cases would be involving defamation, false imprisonment and malicious prosecution, and cases alleging fraud. A jury of 12 members will be used.
The jury system will deal with cases involving defamation, false imprisonment, malicious prosecution, and any cases alleging fraud. A jury of 8 members will be used.
Coroner's courts, for example, cases of death in prison and death as a result of industrial incidents. Circumstances where the death has occurred on the health and safety of the public has been brought into questions. And death while in the public custody or as a result of an injury caused by a police officer in the execution of his duty.
Fields of criminal cases, it can be classified into 3 different groups. Summary of only offences which is tried in magistrate courts, indignable offences which will be tried in the Crown's courts, and lastly, either way offences where it can be tried in both courts. Most of these cases are summary only which at least serious offences in general. For instance, road traffic incidences, 95% of it, of criminal cases are tried in magistrate court, and the remaining 5% of it, most of the defendants will be plead guilty, so the juries are not needed. Hence, juries only decide for only 1%. Referring to the Criminal Law Act of 1977, there was a revision to remove the right to jury trial in significant amount of offences. A number of other cases have been made only summary only since then, whilst giving more power to the magistrate courts to decide. The Criminal Justice Act 2003 also allows trial by judge alone in the Crown Court, where firstly there a serious risk of jury tampering exists, or the case involves a complex or lengthy financial and commercial arrangements.
Correspondingly, in civil cases, the County Courts Act 1984 sets out the following guidelines on when a jury should be used for a civil trial. Where the cases involves, first, libel or slander, second, false imprisonment, thirdly, malicious prosecution, and fourthly, fraud. A case involving the above matters may still be refused a trial by jury if the judge believes the case evidence on other matters are too complicated for a trial by the juries. That is all for today I have today. Thank you and for giving us an introduction to the jury system.
It's time to go back to the coffin.
Thank you for tuning in today, with us today. Next, we are going to watch a new episode, Racial Stereotypes of the Defendants, in the new season of How to Convict a Murder in NBC's.
Breaking news.
Hi.
Hi, what up?
Hi. Hi, analyst cheating. Have you heard about the trial where the trial was so racist? It was what happened to my friend O.J. Simpson case. Black people are always the target of racial discrimination. Not only that, other ethnic minorities are also faced with similar issues.
Yeah, Rob Kardashian. I know it all too well. However, there are attempts to verify the situation. So if you refer to the articles 6 and 14 of the ECHR, or the European Convention of Human Rights, there are actually parallel objectives. So they advocated for and required a trial before an impartial tribunal without discrimination of race, color, language, religion, national or social origin. So not only that, the Human Rights Act 1998 also incorporates the ECHR into domestic law in the UK. So when there is alleged racial bias in the jury, the court must consider the juror's complaint and the effect on the defendant and the sufficiency of the guarantees and steps taken to ensure impartiality in the jury. So there was actually a case that comes to my mind.
What was the case about?
So it was the case of Kuldeep Sandhu, who was charged with conspiracy to commit fraud, and this was actually tried in the Birmingham Crown Court in March 1995. So there was simmering racism among the juries, and one of the jurors actually sent a note to the judge claiming that the jurors were making racist remarks against the accused.
Wow, do you think that it could impede the impartiality of the courts?
Definitely yes. Based on Daly and Patton's racial bias and English criminal trial jury, there are among guarantees and measures taken to ensure impartiality in the jury. This include, firstly, juries must take an oath. So this oath actually taps into the conscience of the jurors to be fair, and it encourages them to put aside their personal prejudice to actually enable the trials to be unbiased. So, however, some may argue that the oath cannot prevent racial stereotype as a whole. So, if you look at the case of R.M. Mirza, where it was confirmed that there was a long-standing ban on the admissibility of intrinsic evidence, which is basically the evidence of the content of the jury's deliberations and the mental processes of the jurors when they were deliberating on the case.
Yeah. I know. There is another step that includes the processes of jury selections. Based on the Juries Act 1974, it enables one to challenge a qualified for actual and apparent bias. Furthermore, the random selection of the juries are heavily relied upon the English courts. It may not be necessary representation of the local ethnic mix, but more importantly, it isn't necessarily racially biased either. Randomness does not amount to equal representation of the societal composition.
So, in addition to that, there is definitely a principle of majority verdicts. So, majority verdicts have to definitely prevent a rogue juror from
Yes.
actually insisting on his or her personal disagreement to the majority. But this can't really stop one or two racially prejudiced jurors from tipping the balance in a majority role. So where race is involved, the majority verdict legislation may have silenced a minority who oppose maybe the racist majority.
Time is running out. Let's go.
Yeah, that's good.
To the commentary of how to convict a murderer, racial discrimination and prejudice is inevitable in every society. Thomas mentioned that he has underestimated the role of race on both all white and mixed juries. A jury with one minority member is likely to behave in a deliberate quite differently from one which ethnic minorities make up quite a substantial proportion of the jury, despite the fact that some may openly disagree amongst themselves about the best way to interpret it and evaluate the evidence. Nonetheless, in a diverse communities, white jurors were found to be more conscious of the race and more censors towards the white defendants in cases involving interracial conflict, more likely to favor other races than white defendants compared to the white jurors living in a predominantly white community. This way in which they constitute juries in the UK may have adverse effects on the ethnic minorities, even in absence of an overt discrimination.
Not only that, based on Cheris Thomas, Are Juries Fair, this problem is exacerbated where gender is involved, as male jurors are less likely to change their minds and female jurors, and thus slightly more likely to convict than female jurors. So the balance of males and females on the jury may affect the trial outcomes, and justice may be thrown more out of balance where the racial composition of the jury is taken into account.
I would actually like to rebut the aforementioned argument. According to Lammy's review on the criminal justice system, successive studies actually show that juries deliver equitable results regardless of the ethnic makeup of the jury or the defendant in question. Juries are actually found to be more consistent in their decision making and appear to be able to keep race out of their decision making. So this is probably due to the increasing media attention, which has focused on many areas where the outcomes of jury trials are actually worse for BAME minorities. So juries are claimed to be more consistent in their decision making and actually do not racially stereotype defendants, while in actuality, judges may be comparatively more inclined to do the opposite or to racially stereotype the defendants.
In magistrates' courts, based on Bina Kadola, juries, not judges, lead the way against racial bias in our justice system. Black, Asian, minority ethnicities women are, on average, 24% more likely to be found guilty than white women. On the range going from 22% more likely for black women to 43% for Asian women. This is because the juries are criticized and scrutinized more heavily than judges. White jurors serve on the all-white juries at Nottingham and Winchester, typically known as racially diverse areas, did not stereotype any defenders as more or less likely to commit certain offences based on their race. This is based on Sherry Thomas, Our Juries Fair 2010.
How is the internet affecting jury?
Breaking news.
Do jurors know what to do about improper conduct in the jury room?
Yes, 94% of jurors surveyed say that they would inform the court if they saw someone associated with the case talking to a fellow juror. In a 1995 case of Kulip Sander, who was charged with conspiracy to commit fraud, one of the jurors sent a note to the judge during the trial to complain about jurors who were making openly racist remarks and jokes about Asians. Another example case is R. and Clark and Anor. In this case, the foreman of a jury reported to the trial judge that a juror knew one of the victims. As the trial has just begun and no evidence had been called, the judge concluded that it was preferable to discharge the jury and to restart the trial on the following day when a new jury panel would be available. As for the case of R. and Mecker and Oz, the defendants were on trial for evading excise on tobacco products. A juror had reported that two partly masked men came to his home, offering him money for information about the case. Although he refused to accept the offer, he experienced considerable fear as a result of this approach. The jury was discharged and the prosecution was later applied for an order under Section 44 of the 2003 Act. With regards to the cases above, it can be identified that the jurors indeed know what to do, as they have been making complaints against any unprofessional demeanor that occurs in the jury room. Do the jurors know what to do about improper conduct in the jury room?
No, as seen in the case of R. and Yang, when staying overnight at a hotel to consider the verdict, 12 jurors consulted an Ouija board to contact the victim's spirit. At the scene, Yang's name was spelled on the Ouija board after the jury asked for the killer's name, and the jury was urged to vote guilty tomorrow. This was in breach of the Contempt of Court Act 1981, Section 8, subsection 1, thus a retrial was ordered. When questioned about the misconduct, jurors said that they wanted to know more information about how to conduct their deliberations. In 2013, Kasim Dewi was discharged from a jury for a pedophile case after commenting about the case on Facebook. Devi told the High Court that he was unaware that he had been a breach of formal order made by the Crown Court judge. He accepted that he was not meant to discuss the case, but believed that he was only prohibited from using the internet to carry out research. By referring to the cases above, it is arguable that since the jurors themselves do not know what amounts to improper conduct that can be held in the contempt of court, then the jury panel will naturally not know either. Hence, without knowing what falls under the category of inappropriate and unacceptable behavior, evidently the jurors have come to realize that any performance of an unethical act, they will not know what to do.
Hey, did you read about the news? In Ireland, Marshall and Crum, after the trial, papers were discovered in the jury room showing that the members of the jury had downloaded materials from the internet relating to the charges before them. The two defendants that were convicted for manslaughter and robbery appealed on facts that they did not have a chance to discuss about the material in the open court. However, the appeal was not allowed on the basis that the materials were taken from legitimate websites that the general public have access to. Hence, convictions were found to be safe.
Wow, isn't it contradictory to orthodox that jurors are banned from taking account of evidence which are not raised in the courts? This defeats the purpose of the general rule to ensure defendants get a right to a fair trial under Article 6 of the Human Rights Act as well, doesn't it? Wouldn't it also be an offense of contempt against courts if these warnings were used, since warning has been given to jurors beforehand?
Yes, it contradicts, defeats the aim, and is an offense. Based on the research by Professor Thomas that was published in 2010, 12% of jurors look for information on the internet in high-profile cases, while 5% admitted doing so in ordinary cases. Anyhow, it should be noted that these numbers may not be accurate, as jurors may not admit that they have relied on internet information when they realize that it is actually prohibited.
Oh, Professor Thomas, I've read a research from her that took place in 2032. According to her research, only 3/4 of jurors know about the rules limiting to the access of internet during a trial. Some know but choose to ignore as they do not understand the logic and harm behind it. 1/5 opt to take the rule too earnestly, thinking that they are not allowed to look at the internet at all during trial, for instance, personal emails, Facebook, and Instagram, while 5% outwardly thought that there were no restrictions on the use of internet. The remaining of the jurors fall within the element of confusion.
Oh, let me look up for Professor Thomas on the internet. Oh, yeah, she also said in order to minimize juror contempt in the new media age, jurors must understand the rules on improper conduct, know how and when to report improper conduct when they see it, and they should be able to do so with ease. And if we ignore these critical factors, then we run the risk of creating the ideal conditions for a perfect storm of juror contempt.
I totally agree with her statements. Notwithstanding, it's evident that internet affects jury trials in many ways. To start off, it's a waste of taxpayers' money as the jurors found in contempt of court will be put into jail. For instance, Carl Sturrock, 29, was on a jury hearing at a case at Newcastle Crown Court in July 2014 where he researched the defendant's previous convictions. He was given a sentence of 4 months in jail, suspended for 12 months, and he was ordered to pay £1,000 costs within 3 months. In Attorney General Bill was jailed for 2 months for using Google to find out further information about the number of investors affected in a fraud trial where he was performing jury service. Research in England has also found evidence of jurors using sites such as Google Earth to visit crime scenes. Another similar case would be A.G. vs. Anne Friel. Joan Friel was sentenced for 8 months for contempt of court by London's High Court in 2011 for exchanging Facebook messages with the accused in a drug trial while she was serving on the jury. Friel also searched online for information about another defendant while she and other jurors were still deliberating. These activities were undertaken in contravention of a judicial instruction to avoid using the internet during the trial. While use of social media by jurors to communicate with parties to a case appears to be rare, it is not unheard of.
Yes, it is also a waste of the court's capacity as there would be numerous trials and overturned verdicts. In 2010, Reuters Legal identified at least 90 verdicts between 1999 and 2010 were challenged due to juror internet misconduct. They counted 221 retrials and overturned verdicts in the 2009 and 2010 period. The Law Commission identified at least 18 appeals in the UK since 2005 related to juror misconduct during criminal trials, while some of which involve internet access or social media use. In R.N. Karayak 2005, a jury had found Karayak guilty of rape and indecent assault on his own 17-year-old daughter. After the verdict, a retrial was ordered because a jury had found internet printouts in the jury room. Lord Justice Judge, sitting with Mr. Justice Creswell and Mr. Justin Fulford, ruled that the jurors should not conduct private research that could have a bearing on a trial. Lord Justice Judge, he said, the internet has many benefits and we do not mean to diminish its value, he said. And it can, however, provide material which may influence a juror's view. If used for research purposes during the trial, it can just as easily influence the juror's mind as a discussion with a friend or neighbor.
As stated earlier, in the past, any juror misconduct would be equivalent to contempt of court. With reference to the Law Commission report in 2013 to tackle the issue of internet use by the jurors, it was recommended that there should be a new criminal offense for jurors who intentionally seek for information relating to a case being tried instead of relying on the general offense of contempt of court. Following the report of Criminal Justice and Courts Act 2015 was passed. In this act, 4 new criminal offences were created to replace the former contempt of court punishment. The first of the 4 offences is the juror researching information of a case that is being tried. The second is jurors shares the details of the research with others. The third offence is the jurors discloses the details of the deliberations. And the fourth offence is instead of deciding the case based on the evidence presented in the court, the juror behaves in such a way that he intended to try the case based on the information not presented in the court.
Unquestionably, there are suggestions to prevent the use of internet during trials. In most cases, educating the jurors about the impact of inappropriate social media use has on trials, as well as the consequences if they get caught, would go a long way to prevent future incidents similar to the ones described above. The second method would be to hold pre-trial education sessions for jurors, and next, by constantly reminding them of the risks throughout the trial process, the risk of social media misuse by jurors during trial would be mitigated. And also, the court can sequester the jurors or even confiscate smartphones and other internet-connected devices during trials to avoid issues arising from social media misuse. However, suggestions like these have been criticized heavily as they may make the court seem to be out of touch with today's society. Loranda Battles, the assistant professor in law and justice at the University of Canberra, also notes that such measure may discourage the people from serving on juries and advocate for a more nuanced and education-based approach. Ergo, the ongoing challenge for courts is to find a balance between protecting the integrity of the jury system and also respecting the jurors' personal freedom.
In retrospect, we will now discuss about the effectiveness of the jury system. For the magistrate courts, a trial which commences on a scheduled date and reaches a conclusion is recorded as effective as a trial. As for the Crown Court, a trial is effective once a jury has been sworn in, regardless of whether they go on to reach a verdict. Controversially, an ineffective trial does not commence on a due date and requires a rescheduling. This could be due to the absence of a defendant or a witness.
According to Professor Sherry Thomas, our jury's fair report, only 31% of jurors fully understood the judge's oral decisions, although over half thought that the directions were easy to understand. Not only that, research has proven that younger jurors aged 18 to 19 were most able to understand the directions, which is approximately 49%. Moreover, the proportion who fully understand legal questions in the case rose to 48% when given written instructions. Therefore, the juries overall appeared effective and efficient, as the report said, by reaching a verdict by deliberation on 89% of charges, with conclusion that was drawn by studies 89% of jury charges. Now, we are now going to delve into cases that possess the highest conviction rates, which would make indeed indecent photographies of children 89%, causing death by dangerous driving 84%, falsification for 79%, murder 76%, drugs 74%, and theft 70%. Among the lowest were threat to kill 63%, attempt murder 47%, and manslaughter 48%.
Not only that, there are situations where the court actually interferes with the scope of the jury system. So, based on Quirk's argument, the Court of Appeal has created for itself the controversial concept of a lurking doubt. So, this is for cases in which there are no explicable grounds for actually overturning a conviction. This effectively allows the court a discretion to quash a conviction where it believes that an innocent person has actually been convicted. It's actually a rarely used provision because it has been criticized for trespassing upon the function of the jury, but it still offers an important safety valve in the system. Some may argue, though, that it can limitedly serve as a check and balance between the relationship of the juries and the court, between the juries and the court. So all in all, there are suggestions to actually reform the jury system. We refer to Ryan Park, who talks about the jury system in South Korea, where they have mixed tribunals, wherein judges and lay assessors sit together in hearing a case. So this joint panel deliberates the case together, and in the end, they issue a single verdict which they have agreed upon. So hence, we have fully examined the process of decision making within the jury system.